So let's talk briefly about what the procedure is. The application is made by submitting a written application to the tribunal that consists of a statement of the facts that you believe the evidence will show, a argument set out in writing of why those facts mean that the right of action is taken away, and inclusion of any authorities that you are relying on. The tribunal's policy, says that they would like to see copies of examinations for discovery included in that application. So the moving party submits that to the tribunal. The tribunal sends out a letter acknowledging it. They say that they're opening a file. So much like the fiscal process, they say there'll be a pre-hearing that will eventually be set up, and that the respondent is required to file their material. And one of the problems is that there is a huge backlog, much like at fiscal. So an application going in today won't lead to a hearing within the next 12 months. The tribunal, when it sets a hearing, can decide whether they want this heard before a single member panel or a panel of 3. They tend to use a panel of 3 when there is an issue of a very important policy that may have application in other cases, or they feel there may be an issue that turns on the credibility of witnesses. The tribunal expects that the parties are going to testify, and that's so even though the discovery transcript may be in the application, the tribunal has the power to summons witnesses, and you tell them who your witnesses are, what you think they have to say. The tribunal will exercise a discretion as to whether they will require that person to be summoned, but generally if there is a compelling argument as to why they should be attending in person as opposed to providing testimony in writing, that summons will be issued. The tribunal is not bound by the rules of evidence. They can accept hearsay evidence, although that goes to weight. They can accept written documents as to the truth of their contents, and that's particularly so with medical reports. They do not want doctors attending, for instance. After the hearing, the tribunal will say thank you very much and tell you that they will render a decision in the near future. And near future usually means more than 3 months. You will get a written decision rolling off the fax machine, and the tribunal's decision is final. The only other remedy is to apply for judicial review, and I can tell you that there has never been a successful judicial review. Well, I'm going to back up on that. There was one, but the Court of Appeal overturned it. So there is great deference given to the tribunal. Its results are going to determine the outcome of whether or not there can be a lawsuit, and it will be very final. One of the problems in this is that judges are expecting that parties are going to raise this issue early, and they are not happy when it's raised late in the game and can cause a delay in the trial. And they may raise that when it comes to costs. The problem with starting very early is that not all the facts are out. And so it may well be that you have to start the application even before the discoveries are there and decide whether or not you're going to continue with it. Costs are not awarded by the tribunal, although a court, in making whatever final orders are required, could decide that this was a necessary part of the action and therefore subject to a cost award.